Good afternoon, good morning from wherever you are, and welcome to this episode of this webinar, where we are going to focus on African competition law and policy. It has been organized by the African Competition and Consumer Protection Center, which is a YouTube channel that I came up with to provide discourse on competition law development in the global north and global south, and how we can learn from each other. So today we are going to have a very distinguished speaker in competition law enforcement in Africa and beyond. That is Professor Elena Fox, who is currently a professor at New York University in the US. She has written extensively on competition law and policy in both the global north and global south, with her recent book with Professor Mo Bacom on making markets work for Africa. I'll share bibliography in the chat because it's very long. And also she's written a lot on design of competition law institutions, and then recently on the need of Africa having a voice at the center when it comes to the enforcement of competition law at the African Continental Free Trade Area Agreement. So today we want to discuss the regulation of digital markets and the place of Africa in the control of global power, and whether the drafted AfCFTA competition protocol provides any solutions for Africa in the enforcement of digital markets. This is a very open session, and that is why I'll now let Professor Elena Fox come in and tell us, does the AfCFTA competition protocol have any solutions for Africa participation in the regulation of digital markets? What should we do? What should we not do, especially in the regards to the enforcement and implementation of Article 11 of the AfCFTA competition protocol? Welcome.
So thank you very much, Bela. It is my pleasure to be here today, and thanks and hello to all of you. And it's my particular pleasure to be able to address this question of Africa and big tech and controlling the power of big tech. And I know a lot of you on this call have already done a huge amount of work on this particular subject. So could I just start by saying a relatively few words, I think, and then maybe we have a dialogue about it. Is that fine, Avela?
Yes,
okay.
That's fine.
So first, to acknowledge the protocol. The protocol is a really great and very needed development. It is so needed because when it is in effect and there is a commissioner or head of the competition authority, it really puts Africa on the map in the international conversation, to be a voice for Africa, to, in some sense, represent the continent, even though there's so much devolution beneath, from the national authorities to the regionals and up to the center. But it is so important that there be a voice from the center.
We all have to discuss about which actually
and so I'm sorry, was that a question or remark?
No, I just muted her. Sorry.
Oh, okay. All right. So, so the protocol, of course, has what you would call the pretty common competition provisions, which include, here it's particularly important, an abuse of dominance provision. And then in Article 11, a specific provision on abuse of superior bargaining power, economic dependence, and then very specifically provisions that are designed to control the gatekeepers that have core platforms. I think this is a great advance, and a question is how it will and should be carried out once the protocol is operative. And so here I want to recognize the really good work you have done, Leila and Wangambi, together with Rafi Masur, and of course Malik always there, trying to understand implementation. And so here I want to say some words that won't necessarily be on the upbeat side, and I want to hear your responses. Controlling big tech is a huge problem. The actions and the implementation of regulations are happening all over the world. Some actions are happening in the United States. Legislation has been proposed specifically for big tech in the United States, but has not yet had traction. The big tech companies and the biggest of the gatekeepers, for example, Google is the biggest of the gatekeepers. Google denies in every single action against it, and there are many, just even the first step that it has dominant power. Its epithet is the competition is a click away. And that really says a lot of how big tech tries to weasel out of what has to be a first step in any action, which is power. And it makes a big issue of it. And a lot of resources are devoted to it again and again. So we're waiting to see how the actions in the US will come out. In EU has had some success in its actions, especially against Google. And of course, EU has adopted the Digital Markets Act, which is much more particular and is a kind of regulation, partially ex-ante regulation, which designates certain conduct as illegal for companies designated as the gatekeepers. And what Africa has in Article 11 reflects some of, like maybe half of those do's and don'ts that are in the Digital Markets Act of the EU. Even EU is not having a really rosy, easy time of getting off the ground. Its idea of having more specific regulation or designation of illegal practices was twofold. One, these case-by-case cases take too long to get to the conduct that is sought to be abusive, and the cases take years and years to resolve when the companies are off doing something else, like they will be off doing combinations with.
Hey, how are you? All good?
And it will look a little different. They'll look a little different when they are companies with AI, and things will have to start and skip square one. In the DMA, the companies, some of them, not all of them, are denying that they're gatekeepers to begin with. As to every single do and don't, if it's complicated at all, the companies are going to have some excuse or justification. So even with US, EU, and maybe 10 other countries in the world, like South Korea, Japan, Australia, of course, UK, even with all of these countries being on it and trying to control the power of big tech, they're in initial and wavering stages. And it's going to take some years before we know if and how they are successful. So this is my thought for Africa. I think it's great that Africa is taking an interest in it and trying to stake out an interest and saying, doing the research like Wangambi has done to show very specifically what Africa needs and why the small businesses are so dependent on the platforms, and how the interoperability element is crucial to their survival and getting to market and getting customers. So whatever happens and whatever I say that might be on the downside, this is all great. It's all very important and constructive. But what can Africa really do that will really be successful? And one question is whether it should be waiting on the sidelines to try to take advantage of what the rest of the world is doing, and in a good sense, ride on it, capture it, and make it its own. So I think one very useful thing, which is in the South Africa report on online intermediary platforms market inquiry final report, is to say, this is in the section on self-preferencing, is to say, first of all, South Africa has its laws that are the prohibition, and then to say what this is respecting Google self-preferencing, what Google does and has to do to comply with the DMA, it also has to do and comply with the South African law. A reason why that is a very good and possibly fruitful approach, even though the gatekeepers will resist that too and say no jurisdiction, and they'll say you have to do it all again. But the reason why it is a possibly really fruitful approach is that South Africa will not, if it's successful, will not have to prove all the elements of the violation again. They can actually, if they are successful, take advantage and sweep into their law what Google will have already agreed to do in EU. So that without something like that, you have to start from ground one. And ground one is, as I just said, really difficult. So now let me just say a few words about levels of enforcement, and also a couple of words about the provisions of the protocol and what the Competition Commission of Africa ought to do. On levels of enforcement, here is just a very general idea. I know you, and especially Leila, has done a huge amount of work on levels of enforcement and when to do it at lower levels, particularly, and how to coordinate at lower levels. And also, you have said that I call it the center, which is African Center. I think you have said, Leila, that something has to be done, at least a learned committee or something has to be done at the center to sort of raise the voice to Pan-African level. So this is my thought, looking at it kind of the other way around. That is not from below, but looking at it from the top. I think that the center, which is African Center, has to first be very selective, but second, be very clear about weighing in, sometimes bringing lawsuits on issues of African importance. And that control of big tech is one of those issues, but it has to be very selective. I think it would be very difficult for the center to be designing exactly what to do in the weeds on catching the big tech abuses. But I think it can have a voice on a general level. I think also that big tech ought to be one of the areas that it is surveilling to look for the best case or cases to bring. And I think that those best cases, which would be both the worst offenses and cross-border, as much cross-border as possible, that big tech is doing these practices cross-border. And this would be very case-specific. So I'm not now talking about regulation and writing rules. I'm talking about deciding on a case or cases that will be very exemplary of abuses. When I was thinking of what is very exemplary of abuses, I thought immediately of a GovChat in South Africa, which I think was totally outrageous, where Meta offboarded this wonderfully important citizen-facing app, and it did so on the, let's call it pretext, but we'll see what happens, that GovChat did not comply with the rules that it had promised to comply with. And I gather that's still in litigation in the tribunal in South Africa. I think that is a really outstanding case of showing the abuse. Then I looked at the protocol. I think it doesn't come within Article 11, but it definitely comes within Article 9. It's an abuse of dominance. And I think that it kind of doesn't matter if you don't come within language of Article 11, but you do come within abuse of dominance. It's fine, and it's fine to claim that both if it can come within both. And I think that's what the center ought to do, to sort of be on top of what's happening in a national or regional conversation on controlling abuses of big tech, and to be selectively bringing the most important cases against the worst Pan-African abuses. So could I stop there and ask for like what you would like to talk more about, or conversation or questions?
Yeah, sure, we can welcome questions if you have any question. But I have 2 questions before the audience asks question. And thank you so much by telling us about what the center has to be general about and also selective about. And I just wanted, if you could tell us something more about the issue of inclusivity and market equality in digital markets, which you've written extensively on it, and how we can enhance the participation of African SMEs in digital markets. As the South African Competition Commission online intermediation platform has shown that African SMEs do not have the same bargaining power as other businesses in the platform ecosystem. For instance, when you look at the case of the Booking.com, it's very difficult for African small hotels and restaurants to compete with the international hotels and chains, international chains. And therefore, one of the findings that South Africa Competition Commission found that there's cases of unjustifiable differentiated treatment when it comes to access of this market. So how can Africa, and especially the AfCFTA Competition Authority, once it starts, how can it use Article 11 in order to enhance access and equality and participation of African SMEs?
Oh, so that is a really great question that I would like to say a few words about. And I see this raised, I mean, both in the work that Wangambi and Rafi have just done, and in the South African report on intermediation, that from both of their standpoints, they've either reflected what you said, or you're reflecting what they said. I'm saying that the small businesses in South Africa need something more for capability for them to be able to do that extra mile to actually interoperate. And a question is, will big tech comply and do that extra mile? To the extent that the big tech is African companies, big tech, I don't see any problem with trying to require them to do it. And I think, incidentally, it would be very useful if when Africa starts enforcing, that includes the African big tech, because there are some African gatekeepers. And that at once, if that is done, it does give a good impression of good rules for everybody. So now think about doing it to the non-African gatekeepers. And I want to sort of try to channel Google, for example. Google says, you don't, it's going to say you don't have a right to catch me on this. If say you're under a provision that says abuse of dominance, or even under Article 11, which doesn't specifically require that sort of extra mile interoperability, but you could argue that it does or should. Google is going to say, this is not my responsibility. I am doing what, and it will probably invoke US law because US law is the best for it. It will probably invoke US law and try to generalize US law as if it were the international standard. And some people think it is, but EU is much more regulatory. And if you invoke US law, the US law goes something like this in that area. Google made the platform. It can do what it wants on its platform unless it is getting more market power. It has to be both a monopoly and be getting more market power by the claimed abuse. And it does not have duties to deal to make smaller firms, smaller competitors better. If that were a claim under US law, it would be dismissed outright. And I just want to pose that because it's in, I like to call it outside of the mainstream of international law, but it is sort of in the edge of the mainstream of law, of even monopoly firms don't have a duty to deal except in exceptional circumstances. And for US law, definitely don't have a duty to pull up rivals that are having a hard time competing. So now let me look at that question in a slightly different way. I know that, of course, we know what the DMA says. The DMA imposes obligations that are not called antitrust. This is EU, Digital Markets Act. The Digital Markets Act says we're not antitrust. We're about contestability and fairness. And DMA has certain provisions in Article 6 that in effect would require the gatekeepers to provide interoperability on a level where this is a facility business needs, more or less. It doesn't say needs. I was just looking for my note. Let's see. It has to where those services are an important gateway to business users. So what is it agreeing to within EU? What is an important gateway to business users in the EU is actually less than what is an important gateway to a lot of African firms. I think that if they're held to the DMA standard, it doesn't go the extra mile. It goes to what the North, the global North, generally needs. So Africa could have law that says, as far as we're concerned, suppose the law is clear, you go the extra mile. I think the big tech outside of Africa will claim no jurisdiction. And they will claim this is an unusual burden on us in addition. And they will also claim, even though they may not have evidence, they will also claim it's such a burden on us, it will inhibit our innovation. That's the kind of argument that comes up. So let me look at it one final way before I turn it back, and that is this. Who ought to pay for enabling the capability so that the African firms can go that extra mile? It's like the helping hand to pull them up so that they can actually take good advantage of the interoperability. One way to think about it is that I don't know how realistic, but that there should be a subsidy for capabilities, for capacity building in Africa, spent by Africa. And that if Africa can pay, if it can provide these capabilities, infrastructure, capacity building, it will pay it back. And actually, it will probably be more fruitful than trying to get big tech outside of Africa to pay. And incidentally, if it's big tech within Africa, question, does Africa want to impose the burden on its own firms? If it doesn't even want on its own firms that are gatekeepers. And so maybe the answer is yes. If the answer is no, this is telling, and one ought to look at subsidy for capabilities. So the equity question, I mean, it's all over. It's very, very important. It's sort of center stage. It's so important, and yet very difficult to come to grips with in a satisfactory way if you're looking for either the market or antitrust obligations to do it. I'm sorry to have to say that.
Okay, thank you so much for the important points you selected, especially on the need to have rules that target both African and African gatekeepers. So to the audience, if you have any question, just unmute and then ask the question. Yes, Mr. Kariuki.
Yeah, thank you, Elena. And I wish to thank you also for the support you've given us with RAFE in doing the work we are doing on digital. But Elena, having said that, and it's an important question when I've been doing this work of mine, people have been asking me, there's a very complicated area for competition agencies in Africa. It's an uncharted path, and taking into account that the African competition agencies have not yet really built the regulatory and skills capacity to deal with this, is that what are your thoughts in regard to, should they wait to build capacity first and then regulate, or they should wait to, they should regulate as they move on? And yeah, what's your take on that? That's a challenge people have been asking me.
Yes, so Wangambi, you're saying, should the national authorities be building capacity or the regional authorities?
It's the national authorities, because even at continental level, is that obviously they will be depending on the national competition agencies to regulate. And taking into account, Elena, you have really focused on the study of the African continent in terms of the competition agencies, is that they are yet to build that capacity even to regulate the traditional markets. So
Right.
how are they supposed to prioritize on this? I have my thoughts on that, but I want to to pick your thoughts.
So of course it depends which agency you're talking about and what level that agency is at. And I would say in general that the agencies should be building capacity, but when they're building capacity for analysis, that the capacity for enforcing against big tech should not be the specific thing they're building the capacity for. They should be building the capacity to analyze when there is an abuse, and big tech would fall into that. But that the main thing they should be building capacity on is to understand on the analysis where there's market power and where there's an abuse of power. And that can be for abuse, it can be for agreements, and it can be for mergers. And so that's sort of basic building blocks on where there is power and where there's abuse. And of course, I understand, as we've talked about, that there are actually wide ranges here. It's not economic science. There are ranges within economics where one could make a very credible case. And so Vela mentioned inclusiveness before. I didn't mention the word yet, but it seems to me that Africa has adopted this idea which is really important, and I totally agree with it, that the inclusiveness concept has to be built into what is anti-competitive, because when conduct is serially making it harder and harder for small firms to get into the market, this is actually bad for competition, it's bad for efficiency, and it's bad for equality. So this should be built into the paradigm, not to say that the market includes everybody, no matter how inefficient and bumbling they are. It's not to say that at all, but that it is to say that there is a range of that word efficiency. And Africa is, as far as I can tell, with various countries are taking advantage of that flexibility. So the building capacity should be building basic capacity. And then as for big tech, it has to be kind of, what I'm saying is like the dome, and big tech is subsumed within it. Does that answer what you meant to ask, Wangambe?
No, you've answered my question, because also my thoughts have always been that even the platforms are affecting the traditional markets. And therefore, if they're not regulated at the moment, even they will distort the well-functioning of the African traditional markets. So as you say, is that it has to go hand in hand. Thank you.
Thank you so much, Francis, for that question. And I also think that African competition agencies, just as Elena has said, should focus on building knowledge and capacity on understanding some of these regulatory issues in the digital markets. For instance, what is self-preferencing? What do we mean when we say anti-steering provisions? When we talk about data portability, when we talk about price and service parity clauses, what is the legal test of all these kind of anti-competitive conduct that digital firms are engaging in? So I think they will learn so much from other jurisdictions that have been able to handle these competition issues. So does anyone else have a question? As you think of a question, I also have another question on the issue of remedies. And I would like your input on the most appropriate remedies that African competition agencies should be looking into when regulating the digital market ecosystem.
Oh, so of course, that's also a very key question, and also an extremely difficult question.
Yeah.
So are you asking it very specifically on big tech or generally?
On big tech. On
yeah. Okay. Yeah. So the easiest remedy and the smallest remedy for in almost all of these cases would be a court order saying, you've done this wrong, you should not do it again. It's an injunction against conduct. For example, Google has been paying billions of dollars a year to Apple to be the default search on Apple. And this is pending trial in the United States right now. And the easiest, simplest, smallest remedy would be say, don't do it again. And that would be almost entirely ineffective. I mean, it should be done. It's not zero ineffective, but Google already has 90% of the market. And if it doesn't buy its way into keeping its 90-some% share, it still has established itself that will keep getting more share. So then the question is, what more? And the biggest remedy would be breakup. And probably even US courts dealing with US firms will be very reluctant to break a company up. And because that's been our tradition, to be reluctant to break up. And it's actually more of a tradition outside of the United States than in the United States. And if, for example, an African authority were thinking of ordering, I mean, even an EU authority, which they're thinking of ordering a breakup, they're probably not going to do it. And there will be questions that will be raised in terms of extraterritoriality and disproportionality that will probably keep them from ordering a breakup. So what would be useful in between? So first you have your injunction against the conduct. Other remedies, no remedy is good. What you really want is deterrence. But other remedies could be, for example, that if it's against Google, that Google has to open its market to other competitors. So other competitors have an equal shot at being the default engine. That's the kind of remedy that is being thought about. And it's recognized the remedies are not good. So this is just a slight deviation. I mean, it is a big deviation from big tech, but you might have noticed in the United States, Live Nation, Ticketmaster had a merger back in 2010. It's a vertical merger. Live Nation owns most of the venues for big performances, and Ticketmaster owns most of the ticketing for big performances like Taylor Swift. And the merger was proposed in 2010, and it was let to go through with behavioral remedies. And Live Nation said, oh, we won't ever use our leverage to get venues to buy only from Ticketmaster, and we won't ever retaliate or threaten. Well, it turned out they did a lot of retaliation. They did a lot of threatening. And the company, as a combined firm, was so big and lax that you might have noticed it caused a great big debacle when tickets were being sold and fans couldn't get the tickets. For Taylor Swift, which here is big name. And the Justice Department just sued to break them up. And we'll see what happens. Maybe they get a breakup this time. The point of that is to say it's mergers were much more likely to say bad mergers get divested. For non-mergers is where we have great reluctance to break up. If power is created through organically, we usually don't break them up. So this is pending now, just as of a week ago, a new lawsuit against Live Nation and Ticketmaster, saying they're using their power. Behavioral remedies are no good. We really need to break up.
Okay, let me allow Kayla to ask her question.
My question is regards the remedies, because looking at the EU, the DMA, and the proposed DMCC of the UK, using that as a blueprint, the deterrent is not really effective, if I may say, because Google, Microsoft, they've had fines in different countries, in the US, in Europe, and they're still doing the same thing. So if we have to purportedly move that same remedy to the EU, to African nations, would that be effective when it's not yet effective in the EU and the UK space?
So you are right. Again, the behavioral remedies do not work. The fines, you just said, it's absolutely true. The fines don't work. The fines, even these what look like huge fines, are a drop in the bucket. And in some cases, where the conduct is particularly egregious, bordering on criminal, the courts would give remedies such as to say that the directors or officials who have been instrumental in the conduct cannot be officials of this firm or any rivals in the field for many years. So that is a kind of criminal remedy. I was staying away from the criminal remedy type because these cases are not going to be tried as criminal cases. And we just come back to the same problem that behavioral remedies and fines don't work very well on these giant firms that have like 3 trillion market cap. They're very rich. They're richer than countries. So it is a dilemma. And to me, one of the ways to try to answer that problem is to have global norms, which we're working towards in a very loose way. Certainly, when Africa says something is wrong under our law and illegal under African law, that's more powerful than a country of Africa saying it. And if the world competition agencies say this is a wrong, it should not happen, it is not okay, there might possibly be some reputational dissuasion of the bad conduct. At least I think it's really important to work towards to teasing out what are the common rules. So I take Article 11 as an attempt to do that. And the Article 11, incidentally, although it's in the competition protocol, it involves consumer protection and unfairness as well as what you would call traditional antitrust. And I think that what big tech are doing needs to be thought of in that broader prism. So if the world, so you have EU as a leader, UK as a leader, Australia as a leader, and then a lot of surrounding periphery, including Africa trying, if we get common rules against big tech, just as notional norms, maybe that will be some pushback of abusive behavior for reputational reasons, if not for fine reasons.
Okay, Kayla.
Thank you. I think the point here, what you said, the economic and the financial impacts, the unfair treatment on consumer, I believe that should be focused on in Africa, as opposed to the economic benefits the country is getting or the state is getting from these big tech companies. If we're focusing more on the unfair treatment on customers, and if one big tech company is penalized, like the deterrent is more like leaving the playing field for years, I believe others would take into shape. And I believe that's the future for digital markets than giving them penalties. We should be looking at the consumer and the unfair treatment to the consumer as opposed to the revenue we're generating from the big techs. Thank you.
Thank you. I might want to ask you to repeat something, but let me first make a statement, but I think I want you to repeat something. I think that the focus in Africa should be, first of all, on the African consumer and business person trying to get the efficiencies on the platform. I think in terms of the benefits of what the big tech are doing, I think that it should be recognized. You can't take out of the picture the fact that big tech are providing benefits to the world. And they could be providing these benefits without the abusive practices, and that's the point. But when you're thinking about benefits to big tech, I think you have to recognize benefits to consumers, including benefits to African consumers, including benefits to African small business that want to be on the platform that, after all, was created by the big tech, and to the African consumers that are looking at what they think is zero pricing. So all of that is a benefit. And so the abuse has to be such that doesn't cut into the sort of essential benefits of the platform. But what I didn't get, Kayla, could you say again on remedy? I think you said what you thought to be a really good remedy, and I didn't hear it. Could you say it again?
Okay, I'm saying I believe more like a remedy would be if these big techs, they are taken out of the playing field for a while. So let's say Google, for instance, instead of asking them to pay $1 million, which is like a pat on their back, telling them to leave the playing field for a couple of months or 7 months or 1 month, depending on what the court thinks, it will serve as a stronger warning than the penalties we're currently seeing.
Okay, thank you. And on a different point, I wanted to say, at some point, this is a totally different point, at some point, the big tech might say, I don't want to do business in your jurisdiction. You're requiring me to do more than makes sense for me. And if it's done at a Pan-African level, it's much less likely. But the big tech are doing this. They are saying, I don't like what you're asking me, Australia, I'm not going to do business here anymore. And then there's usually some kind of settlement of it. But that's one of the things that they do when they don't like what the country is asking them. And if so, that Africa should be, and I don't know the facts, has to be a continent that you really want to do business in. And I feel sure it should be, that it's worth their while. By this, I mean worth their while on their balance sheets to do business in Africa, even complying with law that they really don't like in Africa.
Yeah, and thank you so much, Kayla, for raising that issue. And if you go through the online intermediation platform market inquiry in South Africa, these are some of the remedies that the Commission tried to come up with. For instance, they were requiring the big tech company to provide financial support to the SMEs. And also in some instances, especially in the travel and accommodation industry, to ensure that when they're ranking South African platforms, to put a South African flag on those platforms so that the consumers can easily identify that this is a South African platform that is appearing in the organic search result other than in the paid search result. So I think this will really be an important topic for our next session. And I see we have at least 10 minutes to go. And anyone else who has a question? As I push this final question to Professor Lena Fox.
Oh, I just want to jump
Okay.
in and say that that's exactly the point at which the capacity building, putting that on the gatekeeper, is exactly the point at which I thought that if you're requiring it of African companies first, it has more legitimacy. If you're not, and you're requiring it of the outsider, big tech, the companies are going to say, that's not my job to give you capacity building too. But it's also the point at which the big tech companies will think whether it's worth it for them to continue doing business in Africa. So the more you're putting these financial obligations on the firms to do business in Africa, at some point you could come to what they consider is the breaking point for them, and they're not going to do business anymore.
Yeah, yet if they say they don't want to do the business, yet that the gateway for business users to reach the end users. And many businesses are now economically dependent on this platform. So it will really be a big blow to all the market participants. So you talked, in Africa, we are having different levels of competition enforcement. Now we have the continental, the regional competition agencies, and also the national competition agencies. And under the EU DMA, I think the EU Commission has the exclusive authority to enforce the DMA, and the NCAs have been given the obligation to coordinate and support the EU Commission. So I really wanted to have your take on the issue of how can coordination between the AfCFTA competition authority and regional competition regimes on one hand, and national competition agencies on one hand, occur in practice when it comes to the regulation of digital markets.
So did you say the coordination between
Yeah, the
R-
coordination, like
now-
should the AfCFTA have the exclusive authority, like the EU Commission, in the regulation of digital markets, or what should really happen in practice?
Oh, so first of all, I don't think anyone should have exclusive jurisdiction. I think it works very well in many places in the world, even EU. Nobody, well, EU except for for certain big mergers. For abusive dominance, nobody has exclusive jurisdiction, and it works fine. And it works fine in the United States too, with the states having a lot of authority to sue also. So I think that the top, the center, ought to be simply carving out and taking for itself at the highest level the biggest issues that are going to have the biggest impact. Then I think where you have functioning regional competition authorities, it would be great for the functional regional competition authorities to take a big hand in this matter. They have other priorities, and I want to mention other priorities in a moment, but to take a big interest in it, like for COMESA to take a big interest in it, and to coordinate with other regional authorities that are situated at such a level that they have the resources to be doing the thinking about it. And a lot at the national level. A lot of the complaints, I think complaints ought to be invited. Complaints of abuses ought to be invited. The complaints are probably going to start out at the national level. And then I think you have to just see when complaints are really cross-border, and then when they're really cross-border and within a regional, then that's exactly an issue for the regional authority to take forward. Wangambi mentioned priorities. You mentioned the word priorities, and I wanted to mention that too right now. So like, where does control of big tech stand in terms of priorities? And let me put it this way, if it's not already in the area of an abusive dominance or anti-competitive agreement, so, but is in an area where you're going to have a hard time proving abusive dominance or anti-competitive agreement, that is covered by Article 11, but I think probably should not be a priority, because priorities for the center and for a lot of the regionals, priorities are catch your biggest anti-competitive mergers, catch your biggest cartels, and especially cross-border cartels of the greatest impact. And number 3, which might also be a number 1, if it ever gets sufficient traction, is the cross-border restraints where the government is implicated, and they are state restraints combined with private restraints. They're usually vested interest restraints. If those restraints are not caught within Africa, continental Africa, competition law will do almost nothing to help integrate Africa. Those restraints are at the core of getting rid of them, of integrating Africa. Some of them are now caught by the law, or could be. And for Africa, for the fair trade agreement, free trade agreement, there is the complementary body of law that is meant to catch anti-competitive undue state restraints, and on the other side, the competition law to catch the private restraints. And those two parts of the African Free Trade Agreement absolutely must coordinate together to be sure that they catch all undue border restraints that they can. that in one sense ought to be a #1 priority. So if you have border state and vested interest restraints as #1, and you have mergers and or cartels as 2 and 3, tech to me comes in 4.
Okay.
Odie had something to say.
Good day, Professor. No, I was just giving a thumbs up. It was just a good point.
Oh, okay.
Thank you.
Thanks.
Thanks.
Yeah, so we are coming to the end. We have 5 minutes, and maybe in conclusion, could you tell us whether Africa has the political power to go after the big tech companies? And how can we handle this, the politics of the game?
One thing I would like to know, maybe somebody can send me afterwards, how big a market is Africa for the big tech firms that are not African? So the GAFA, the GAFAM. So the more the companies get important business from Africa, the more leverage you have.
Okay.
And so I would love to see that Africa is really an important, call it client base, which could be consumers and business, really important and valuable to big tech.
Okay, thank you so much. So Africa has the leverage of the market, and we can use that to push for power. Anyone was any?
Another way of thinking about it is if all of these tiny and small firms that simply want that extra helping hand to be interoperable, if they get to be interoperable, how valuable is that to big tech? Should they be really wanting to do that because it's in their interest to lend that helping hand?
Okay. Anyone else has a question? So if there's no question, I want to take this opportunity to thank Professor Elena Fox for accepting to be with us today and to discuss this important issue. As Francis said, this is a new area. It's very complex, even for the EU and the US. There are so many emerging areas, and therefore we'll continue learning from each other. And I'm so happy Malik is also here from the AfCFTA Secretariat, and therefore we will continue having this kind of engagements. So next week we'll have a session with Francis Wangombe. I'll share it on my Twitter and LinkedIn pages, where we are going to discuss the do's and the don'ts of enforcing the competition in digital markets by emerging economies. And then we'll have another session with other speakers to discuss the India Digital Markets Act, and we'll also have Professor Mo Bakom talk about the abuse of economic dependence in digital markets and the AfCFTA. So looking forward to seeing all of you in our next session. Thank you so much.
Thank you so much, Leila, and all of you. Thank you.
Okay, super.
Thank you, Professor and Bella. Thank you very much.